Portfolio Recovery Associates is a debt buying company that purchases old, charged-off debts and then tries to collect on them, often by filing debt collection lawsuits. Portfolio Recovery is one of the largest consumer debt buyers in the United States. Last year, Portfolio agreed to settle allegations in the state of New York that they continue to pursue consumers even though the statute of limitations had expired on the debt. The settlement was entered into by Portfolio Recovery and a company called Sherman Financial Group for a total amount of $16 million, as well as another $500,000 in penalties. Now, Portfolio Recovery is one of the largest and most active debt buyers in the state of Arizona. Each and every month, it files hundreds to thousands of debt collection lawsuits against Arizona residents. Most of the debt collection lawsuits end in a default judgment because the consumer simply fails to take action. In this video, I want to go over some of the initial steps that you must take if you want any hope of winning your case. You've been served. Now, getting served with a lawsuit can be a really unsettling experience. It feels like such an invasion of privacy to have some process server knock on your door, usually late at night or early in the morning, and drop off a lawsuit. As stressful as this event can be, it's important to keep your head and write down some very important information. First, write down the day that the process server dropped off the summons and complaint. This date will become very important in calculating when your written answer is due with the court. Next, count out 20 calendar days, including weekends, and circle that due date for your answer. Now, in Arizona, you have 20 days to file a written response. If you don't do that, you run the risk of having a default judgment entered against you. Let's talk about the answer. Now, in order to avoid that default judgment by Portfolio, you have to file a written answer that responds directly to the allegations contained within Portfolio Recovery's complaint. It must be filed within 20 days from the day that you were served. Now, while some people will start this process on their own, it's my recommendation that you at least speak with a consumer rights attorney before you decide to represent yourself. Attorneys like myself fight these junk debt buyers all day long, and there can be real value in having an experienced fighter on your side. I've seen many people who decide to go it alone, draft the answer, and admit to a bunch of stuff they shouldn't have and frankly didn't need to. If you live in Arizona, I'm happy to meet with you for free. I discuss your options and let you know what you can do. If you don't live in Arizona, I recommend you find a consumer attorney in your hometown. You can do that through the National Association of Consumer Advocates at naca.net. There you'll find lawyers who deal with junk debt buyer lawsuits on a daily basis and can give you the best chance of winning. You may want to know, how good is your case? Now, Portfolio Recovery cases are pretty similar. However, you won't know for sure how strong or weak the case is until you receive your initial disclosure statement. Now, in Arizona, there's no such thing as a trial by ambush. Each side has to disclose all of their witnesses, their documents, and their evidence they intend to use at trial well beforehand. They even have to disclose their legal theories. Now, this is required to be exchanged by the parties within 40 days after the answer is filed with the court. Once you receive the initial disclosure statement from Portfolio Recovery Associates, you'll have a much better idea of how strong your case is, and more importantly, how weak Portfolio Recovery's case is. You may want to know if trial is a good option. If the evidence or lack thereof you receive from Portfolio Recovery is lacking, then the trial may not be a bad option. Before a judge can grant judgment against you, Portfolio has to prove, 1, that you had a contract with the original creditor, 2, they have to prove how much was actually owed, and 3, they have to show that your specific account was actually transferred to Portfolio Recovery. If, based upon the evidence that they disclosed, they can't do that, the trial's not a bad option because you have a good chance of winning. However, if the evidence they disclose is strong and admissible at trial, then you may want to consider settling the debt by offering Portfolio an amount that's less than what they're claiming is owed. The important thing to remember about trial is that it is an all or nothing end to your case. The court's not going to find some number in the middle and make you pay that. You'll either win your case and owe nothing, or you'll lose and get hit with a judgment for the full amount. If you've been served by a lawsuit from Portfolio Recovery Associates, or if you're right in the middle of your case and you are stressed out of your mind, give me a call. I can help. I handle these cases all of the time, and there are many different options to bringing the case to a good resolution. Thanks for watching.